Okay, well, let's just go through a hypothetical that is a little easier. You've got a case that's going to gain the United States people $180 million. You've got another case you don't want to go to the U.S. Supreme Court. You trade those two cases because you don't want to have that happen, and then you tell somebody, you know, we'd like to keep things quiet. Let's make sure we don't disclose it. Is that right or wrong?
Well, there are a whole variety of reasons why we as a government, Justice Department, decide not to become involved in key TAM cases, the strength of the evidence, questions of law, position of the claim.
Is it okay to trade a case you don't want going to the Supreme Court for a dollar damage case? That's the real question here.
Well, one has to take a look at this in its totality and decide exactly if there were...
Okay, I'll take that as a yes. It's okay to do that trade in your mind.
That was not a yes. It was not a... I was trying to answer the question.
Okay, well, you know, Mr. Attorney General, I need a yes or a no before you go into the long dialogue. Otherwise, I'm wasting my time.
The decision not to take over the False Claims Act case did not end the case.
Well, you may say that, but the plaintiff who saw himself abandoned didn't see it that way. But let me go on to another line of questioning.
Had the ability to try the case. I don't think it worked out well, as I understand it, but the case was not over simply because the United States did not become involved.
Right, but the case going to the U.S. Supreme Court was over.
We do not become involved in key TAM cases 80% of the time.
The case going to the U.S. Supreme Court was over as a result.
Well, as the decision was made not to pursue that case.
Okay. So the American people were denied the highest court considering a case. That's an undeniable fact. Let me go through some questions here.
That's incorrect.
I've been working with.
That is a fact.
Well, we'll let the people decide whether they were denied a Supreme Court decision.
Typically, you do, but
Mr. Attorney General, our investigators have seen 34 of the 35 admitted emails that violate the Federal Records Act. They have only seen the to and from. They have not seen the deliberative contents, and they have not seen the remainder of the 1,200 emails. Mr. Cummings, my ranking member, joined in a letter requesting that we have the full contents pursuant to our subpoena of all 1,200. Will you make them available to the committee based on our bipartisan request?
I will certainly look at the request. It's not something that I have personally been involved in, but I'll look at the request and try to be as responsive as we can. I'm sure there must have been a good reason why only the to and from parts were provided.
Yes, you didn't want us to see the details. Mr. Attorney General, knowing the to and from,
typically do.
Knowing the to and...
I'm not going to stop talking now. Characterize something as something
Mr. Chairman, would you inform the witness as to the rules of this committee?
That is inappropriate and is too consistent with the way in which you conduct yourself as a member of Congress. It's unacceptable and it's shameful.
The gentleman has the time, and the gentleman may ask the questions that he deems appropriate.
Thank you, Mr. Chairman.